Hi everyone, Real Deal Around Town is back. This video is going to be on one of my educational series on the open meeting law. I know it's somebody's got to do it. The people that I'm dealing with in my town are just not paying attention. Um, I'm I don't know where they're getting their information, but it's not from the open meeting law. They're only asking town council what they want to hear. They're they're directing their questions in such a way that allegedly town council will answer the question that they want answered, but I, according to what they say, my town officials are saying that they asked town council something and town council answered a certain way, and I'm like, there's no way town council said that what you did was okay. There's just no way. But if town council did, then we need to look for another town council. But I don't believe you. I believe town council, but I don't believe you. So we're gonna read. This is a reading class, I think, but we're gonna there's something called Commonwealth of Massachusetts regulations. Now, these are not laws over and above everything else. What a CMR it's guidelines, it's a protocol, the steps, the how to do whatever it is it's defining. Every law has CMRs attached. Trust me. And excuse me. So we're going to cover the CMR. I think it's 940 CMR 29. And that is the one that covers open meetings. Now, I'm only going to today only talk about what a board, what a public body, they call them public bodies. When a public body receives an open meeting law complaint, there's certain steps they're supposed to take. I'm going to read from the CMR what that is. But before I go there, on when a public body gets an open meeting law complaint, it's actually in 3 pages. I think for complainants, it's important to include all 3 pages when you send it into your public body because they won't read the first page. If you don't send the first page, they're not going to read it somewhere else. They're not going to do the right thing. So I've learned that you have to include the instruction page, but even then, I did that with my most recent open meeting law complaints, and clearly the boards didn't read it, even though the instructions for what they're supposed to do with it are very clearly spelled out. I don't know why they found it necessary to do something else, but I'm going to give this class. This is an actual class, I think. I don't know what it is, but we're just going to go through the section of the CMR 29 that talks about open meetings and how to respond to a complaint. It's very easy to understand. Now, I've been having difficulties getting this stuff done right. Let's see if I can do it. Get the right window there. How's that one? Okay, so we have part of it. I have to, let's see, preview. Get the right window. I think this is the right one. Okay, so this is 940 CMR. It goes under the Office of Attorney General. Yes, 940 is the Office of the Attorney General. 29 is the open meeting section. I don't want to go over the whole thing. We're not doing all of, um, we're not doing every possible thing about trying to find a zoom out, zoom in button. I think that's going to be okay. I have to double check here. I don't want to. I think we're all right. Are we okay? Let me go all the way out. Oh, I got to shrink it again. Okay, we're there. Almost there. Hopefully that's better. So I just want to make sure that everybody can see what I see. I make mistakes, and I went through a whole video thinking that everybody was going to see what I was seeing, and it wasn't true. So this is how it starts, but I'm going to zip down to, I think it's 05, if I'm not mistaken. I'm not going to go into all the other meeting notice stuff. I will do a video on everything here, But right now, because it's the crisis happening in my town of Townsend here, since they don't know what to do with a complaint, yes, it's the whole complaint procedure. So I'm just gonna, yeah, this will be fun. Yeah, we're just gonna go, yeah, that's what we're gonna do. I'm gonna go through what happens when a complaint is filed. This is a lot of reading. All complaints shall be in writing using the form approved by the Attorney General. This is available on the attorney. You can just Google open meeting law complaint and it'll come up on Google. If you're not in Massachusetts, you'll probably have to add Massachusetts, but your internet already knows where you are. Big Brother's watching. You can get the form, the Attorney General's website. And if you can't find it, your town clerk is supposed to be able to provide it for you. But it's easier to just download it because then you can fill it out online. You don't have to do all kinds of stuff to get it where you need it to go. Public bodies or the municipal clerk, in case of the local public body, should provide any person on request with a complaint form. So even the public body is supposed to do it. Oh, usually the clerk. Just do it online. It's much easier. Let's see. So for local public bodies, which is any board or committee, okay, they can be elected or appointed, it doesn't matter. The complaint shall file the complaint with the chair of the public body, who shall disseminate copies of the complaint to the members of the public body. The complainant shall also file a copy of the complaint with the town clerk, who shall keep filings in an orderly fashion for public view on request during regular business hours. For all other public bodies, the complainant shall file the complaint with the chair of the relevant public body, or if there is no chair, then with the public body. That means if there's no chair been appointed, just send it to everybody on the public body that you can find. Just get it to them. They're supposed to deal with it. They're not supposed to ignore you, even though some will try. The complaint shall be filed within 30 days of the alleged violation. If the alleged violation, could not reasonably have been known at the time it occurred, then within 30 days of the date, it should reasonably have been discovered. And that can be, that's usually related to minutes, because minutes, boards are required to do minutes, and they're required to do them within 3 meetings, or with 30 days or 3 meetings, whichever is longer. And that can go into 90 or 120. That can go way longer. I'm dealing with one right now. I'll be filing a complaint against the Townsend Affordable Housing Trust if I haven't already done so at the time of this video, but we shall see, because they haven't done minutes for the September 12th meeting and they're gone beyond their 3 meetings. So they're going to get another one. Lucky days for them. So within 14 days after receiving the complaint, this is the board that when you're on a board and you get the complaint, you have 14 business days after receiving the complaint to respond, to do a lot of things. The public body shall meet to review the complaint's allegation, take remedial action if appropriate, and send to the complainant a response and a description of any remedial action taken. That means a public body receives a complaint. The chair will get this complaint. They will send it to all the members of the public body. Then the chair will post for a meeting at some point. They can put it as part of the agenda on another meeting, but of course they have to post this like any other meeting 48 hours in advance of the meeting. It has to be on the agenda, posted properly. But in that meeting that they have must be with less than 14 business days left. I mean, from the time that they received the complaint. And that's usually the same day it was sent, because today it's email. And you can't say, well, I didn't open my email for 2 weeks. That doesn't work. That they don't buy that one. If it was sent by email, you got it the same day, unless it was like 11 p.m. I mean, there's reasonableness to these things. So within not on the 15th day, on the within 14 days, you have to make that meeting happen, discuss it, and decide on what you're going to do. You're going to do up a letter, basically, to the person who complained and send it to them after you have this meeting. And all this has to happen within 14 business days after receiving the complaint. Okay? This is not rocket science. Then you also will send a copy of the complaint, the response, and a description of what you did to the Attorney General as well. And that's at open meeting or open government. It's on the complaint form. They have a very easy email address, and it's right on the complaint form. All of this information is on the complaint form as well. This isn't a secret hiding spot on the internet. Okay? Okay. Any remedial action taken by the public body in response to a complaint shall not be admissible as evidence that a violation occurred in any administrative or judicial proceeding against the body related to the alleged violation. That means this is not going to be evidence to be used against the body when it goes to court, because it could. If the public body requires additional time to resolve the complaint, it may ask for an extension from the Attorney General by submitting a written request within that 14-day period. And it must be reasonable reason, a good cause. There has to be a reason why you didn't. It's not like we didn't know what we were supposed to do. It can't be, it has to make sense. Like you were not gonna be able to get a quorum together. That is a good reason. If you had a bunch of meetings between the time that you received the complaint and the 14 days and you want to get an extension now, that's not a good reason, because you've already had multiple meetings. Like, I'm dealing with our Board of Selectmen. I don't understand why they never scheduled a meeting for this. They're out of time. I'm going to have to contact the Attorney General and ask for assistance. Okay, the Attorney General will also notify the complainant. Everything that goes, everything's a public record. Everybody has to understand this. Everything related to an open meeting law complaint is public record. And the complainant is going to be notified of everything that happens. The Attorney General is going to notify the complainant everything that happens. Every notice that goes to the Attorney General is going to be CC'd back to the complainant. So I don't understand why people think it's not. So if the public body needs additional information, the chair may request it from the complainant, but it has to be within 7 days of receiving the complaint. I've never had anybody do that. The complainant shall respond. Then the complainant has 10 business days to respond to that. The public body will then have an additional 10 business days to receive the complaint's response, review the complaint, and again, do this whole meeting thing all over again. All right? So if at least 30 days have passed after the complaint was filed, and if the complaint is unsatisfied with the public body's resolution of the complainant may file a complaint with the Attorney General. That's when the open meeting law complaint becomes an open meeting law complaint. It's really nothing until everybody does their responding, and then the original complainer says, oh, this is BS. I don't like this response. And I think that they're telling me they don't think they violated the open meeting law and that I'm a jerk. So I have to send all of this material to the Attorney General and make it a real complaint. And that's when everything starts. Okay? No investigation's done or anything until the complainant is not satisfied with the response by the public body. So I don't understand. I mean, I understand, but I don't understand why public bodies don't understand. Could not reasonably have known. Okay. What? The Attorney General more than 90 days of delivery. Oh, okay. The Attorney General shall decline to investigate complaints filed with the Attorney General more than 90 days after the alleged violation. So it has to be, all this stuff has to be filed with a timely manner, is basically what it says. If you need more time, they will give more time if there's good cause. Just because you didn't feel like it isn't good enough. So I've got a couple that I'm dealing with from 2 boards that have not responded to me with their response on the complaints that I made. So I'm going to be requesting not additional time, I have to request assistance from the Attorney General. This is not in here. Okay. It's on the form, but it just says, because I think because it's not in the law, there's not even in the CMR what to do. On the form, the Attorney General advises complainants to file or contact the Attorney General's office for assistance. I think at that time, in which they have done with other boards in other communities, is contact the boards and say, hello, this is the Attorney General here. Your complainant has requested assistance as you have not followed Mass General Law 30A, Section 18, blah, blah, blah. So you need to respond to the complaint. You have not done so, and therefore we are in, if whatever, I don't know what they're going to say, because I know that one board has met and they've just chosen not to tell me about it. They've not responded to me. I don't know why. And the second board, the Board of Selectmen, has not even had a meeting. So I think they'll just tell the Housing Trust to just send a response to Cindy and we'll go from there. But I don't know what they're going to do with the Board of Selectmen. I think they're going to remind them, give them a few days, not too many, to have their meeting and do what they're supposed to do. I don't know. I don't know what they do when boards refuse. I know there are some determinations listed on the Attorney General's website that shows some boards that have had trouble with that, and they end up getting hit with intentional violations at some point, because boards that do that, they'll start, if they're not participating in the process, then they're just not going to follow the law anyway. So it's kind of strange. Okay. Now, this is something that I think is going to come up, but I don't think it can come up, but I don't think it will. I'm not sure. I know that some people are going to read what they want to in this, but it says mediation to resolve a complaint. One thing that boards can do is go to mediation on some of this. Like if a complainant files 5 complaints alleging violations of the open meeting law with the same public body or within the same municipality within 12 months, upon the 5th or subsequent complaint to that public body or a public body within the municipality within the 12-month period, the public body may request mediation with the complainant at the public body's expense to resolve the complaint. I'm sure the Attorney General is going to start sending advisements to my town because I have filed 5. Once we get through this week, there will be 5 to my town, at least, maybe 6 in a 6-month period. Mediation, it is a kind of voluntary thing. In this case, it's coerced. It's coerced, but it's a voluntary thing. You don't have to do it. And a mediator is not an arbitrator. They don't tell you. They don't make rulings. They just try to help ease whatever's going on that would cause somebody to file all these complaints. In my case, it's because the public bodies are violating the law. I'm not filing frivolous complaints that don't have determinations behind them. Mine are real. I haven't, like, a frivolous complaint is complaining about something claiming something under the open meeting law that doesn't come under the open meeting law. I go into examples within my community. Even Veronica Kell has filed frivolous ones, but it has to, filing like public record things, they didn't do this for me, or they talked about something that wasn't on their agenda. And the agenda doesn't have to list everything. They can have a heading, and a lot of times a topic will come up where a conversation will come up that isn't specifically listed, but it does fall under the topic that at hand. They don't give out determinations for that. Sometimes they won't even consider them. They just decline to even investigate. So some of those are frivolous. So if a conversation digressed, sometimes a conversation will actually digress into something that it shouldn't have been discussed. But the body will often, when that happens, I've seen it happen a lot in my town and in others. Like, oops, wait a minute, we're going off topic, and the chair does what they're supposed to do, and they reel it back in and get everybody back on track. And it only lasts, the digression is only for a minute or two, and they didn't vote or anything. They just went off topic, and those usually don't end up as anything serious. Warnings will come up, but Attorney General doesn't make a determination just because somebody got into a conversation that got out of control. They try to help. So the mediation, it's at the public body's expense. So if my town wants to do this mediation thing, they have to understand that they got to pay for it. And it ain't cheap either. I don't know what it costs, but it's not free. And no, you can't use the mediation from your employee assistance program. No. If the mediation doesn't produce an agreement, the public body will have 10 business days to from the last joint meeting with the mediator to respond to the complaint. So it's an extension, but it's a costly one. And the mediation isn't going to come up with an answer necessarily. Nothing may change. And it just adds more time and expense to dealing with this. You have to look at each case, and that's exactly what this CMR is explaining. That once you hit the 5, every time a new one is filed, then the reminder about mediation is going to be advised. The attorney, if a public body decides to go with mediation and the complainant declines to participate, nope, I don't want to do that, then the Attorney General may decline to review the complaint, which defeats the purpose. So it's kind of if a community wants to spend the money, they can force a draw. But that doesn't mean it'll change. My request to my community is to please stop breaking the law. Read this, do something other than just think that you want to make me the enemy. This doesn't make any sense. I'm not the enemy. I'm only reporting your violations of law, and I haven't been wrong yet. And I'm confident. I'm completely confident that the complaints I've made are going to be found to be a determination of, yes, you violated the open meeting law. So it goes on about mediation. And one thing about this section, this doesn't end. There's nothing that can stop anybody from filing an open meeting law complaint. You can't turn around and write letters. You can't get a restraining order. You can't get a no trespass order. Strictly based on somebody you don't like, that somebody is sending you too many open meeting law complaints. You can't end that because it's a First Amendment right to seek a redress of grievances from your government. That's in the First Amendment. The right to, you're going to make me, now I'm on the spot. It's on my YouTube channel. I have the First Amendment listed, and you have the right to seek a redress of grievances from your government, guaranteed under the First Amendment to the United States Constitution. And it's also in the Article 16 of the Massachusetts something. Oh, it's in our Constitution. It's Article 16 of the Declaration of Rights, Massachusetts Declaration of Rights. I should have said at the beginning of this, I'm not an attorney. I'm just a citizen trying to explain this to people. So I'm not necessarily can spout off laws off the tip of my tongue. So nothing in this shall prevent a public body from seeking mediation, and only mediation requests that follow the requirements will trigger the application. and nothing shall prevent a complainant from filing subsequent complaints. However, the public body can continue to request mediation, and that's that. Now, I'm not gonna. I don't want to make a complete video on the open meeting law because there's a lot to it, and I like to explain things a little bit more in depth from what they have to be, what's actually printed, and give some examples. So it takes sometimes hours to explain things that are really 5 minutes of reading. So I'm going to do other videos on the application process, the complaint form, and such. But this is a very current issue for me in my town where I really believe that the two boards, I have two open meeting law complaints that are at their deadline and they haven't followed this step at all. And I'm concerned this is a new twist, that they've decided now to be unresponsive. Board of Selectmen haven't even acknowledged that they received it. Well, they did acknowledge outside of a meeting that they received the complaint, and even town council was in the conversation. So, and I saw it with my own eyes and heard it. So they can't say, and that will be part of my request to the Attorney General, that they know and they know what they're supposed to do and they've chosen not to. So it's very confusing. But I wanted to do this video to explain to whoever wants to listen what a public body is supposed to do in the event that you receive a complaint. So that's that. All right, that's all I'm going to say for now. And have a great rest of your day, and stand by for another video. Thank you for listening. And make sure if you can like this, share this, do tell your public officials about this video because they're not listening to me. Hopefully, they'll listen to you. All right. Thank you. Have a good one. Bye.